Hello, this is Marcia Getting, and what we're going to be looking at today is some more information about estate planning, and what we're going to focus on are wills and trusts. My name is Marcia Getting, and I am with the Department of Agricultural Economics and Economics, and an extension specialist in family economics. And I have been working in this area for quite a few years and get lots of questions about wills and trusts and what happens when I die without writing a will. So that's part of what I'm going to be sharing with you today. Several years ago, I started something just a little bit different. What I wanted to do is sort of jazz up my presentations a bit because I was afraid they were coming a wee bit boring. So I love wildflowers, and I decided that sometimes wildflower names can help us remember some of the different kinds of topics. So I'm going to use the wildflower names as triggers, and I hope that they will help you remember some of the information about what you've seen today. This particular flower is called a steer's head. And I love to ask my audiences what they think it is because to me it seems so obvious. But yeah, when you see it for the first time, you go, my goodness, what could that be? But once you see the eyes and the nose and the ears, that's a steer's head. So that's kind of my clue to say that I want to steer you towards the advantages and disadvantages of having a written will. I also want to steer you towards the advantages and disadvantages of a living trust and a testamentary trust. And this is the first flower that will maybe give you an idea of the topic. This is an example of a baneberry flowers, and these are baneberry berries. And this reminds me of the phrase, I don't know if you've heard it before, but so-and-so is the bane of my existence. Probably not a complimentary item, but here's an example. Here's a mother who wrote her will, and normally an attorney doesn't want to put these kinds of things in a will, but this lady was adamant. She said, my only son David is not to receive a single penny from my estate for reasons well known to him and to my friends and family. And for the further reason that during his whole lifetime, since he attained majority, he has been the bane of my existence. He has been disobedient, ungrateful, and a constant source of humiliation, anxiety, and sorrow. Ooh, this is a really tough will, but it's an example of a mom that really had strong feelings about her son, and maybe fortunately or unfortunately, those were her last words. So if we look at what's going on in the United States, we know that about 7 out of 10 Americans die without writing a will, and it's very similar to that in Montana, and I found similar at the meetings I conduct across the state. So what we know is if we have that many dying without a will, what the Montana legislature has done is passed a law of what they call intestate succession, and that's dying without a will. Well, let's take a look at a will. Basically, it's just a written document that describes how its maker wants property distributed after his or her death. So that's the thing about a will. It is going to control the property that has a title. So let's take a look at that. Now, once you get your will written, a lot of people think that it's valid. You know, I've had it witnessed, I've signed it, and therefore it's the law. But really what happens with a will is once you pass away, then 5 days later is the earliest that a will can be submitted for probate. So why we're putting the will through the probate process is to make sure that then what is contained in that will be followed. Now, I have a little statement down there about saying unless all property is non-probate property. And that brings us to, well, what's non-probate and probate? And anything that you have, for example, in joint tenancy with right of survivorship with another individual does not go through probate. Same way, if you have a payable on death designation on your checking account, it goes directly to that individual and doesn't have to go through probate. So now we have some people out here in Montana that have taken advantage of payable on death, transfer on death, and beneficiary deeds with their real property. And what comes to pass is really the will does not have to be probated because everything has been taken care of with a contract. So how old must you be to write a will? Well, age 18 or more. That's the first requirement in Montana. Montana says you must also be of sound mind, and that's described as knowing the nature of your property and know those whom you would leave your property. And here's an example of a dad's will. Dad said, being of sound mind, I spin it all. And that would be kind of nice to come out even. Now, if you've heard of a holographic, or some people call it holographic, a holographic will is one that you write in your own handwriting. Your signature's there, the provisions that you're writing about who you're leaving the property to, that is a holographic will. And if you have a holographic will, no witnesses are necessary. But if you have a formal will, now this is one that's typed or been done on the computer, then we have to have two witnesses that are watching you sign the will. Now this is a question for you to think about. This is a case that I ran across where a man wrote his will on motel stationery in western Montana. And this will was written in his own handwriting. And the question is the will valid? Well, I would have thought so, but I would have been wrong. Because what happened is the judge rejected that will because not everything was in the testator's handwriting. And if you think about motel stationery, usually at the top there's a photograph of the place or the name and address of the owners and all those kinds of things. And for this reason, the judge rejected that will. So here's an individual that thought he was doing the right thing, and it turns out it didn't work. So once a will has been rejected like that, then what happens is it goes under Montana law of intestate succession. Now, if you've already got a will and you've decided that there's some parts in there that you no longer like, well, you have this tendency you want to mark it out or you want to add words and then just put your initials on it. Well, don't do this because what happens is the judge typically rejects a will that's submitted like this because there's no way of knowing if it was the testator, that's the person that wrote the will, or if it was somebody else that did that. So don't do that. Now the whole thing is that once you've got a will, and I think several of us will have wills at different times in our lives because we change. When you start out single, we get married, you have kids, then you have grandkids. So there's times that you want to change the will to better reflect your wishes at that point in time. And so you can change a will as long as the testator remains competent. So we'll assume you're competent and therefore you can change the will. And there's ways that you can do this. You can simply revoke your prior wills. And that is one of the first paragraphs that we see all the time. I hereby revoke all prior wills. And that is a way that we can tell which will should be paid attention to. It'd be ideal if we destroyed them, but some people hang on to them. And that's where you hear the court cases where someone brings up one from 1990, and then here's another one from 1993, and they go through all this business then. Was the person of sound mind when they signed the second will, particularly if somebody's been disinherited? The other thing that we can do is so easy today is make an entirely new will. That means we just go in, start all over, and the attorney will fix that up for us. And then the third way that we can change your will is to simply add a codicil to the present will. Now, a codicil is just a paragraph within your will that you wish to change. So once you do a codicil, then that has to be signed and witnessed just like your regular will. But I don't know that we see as many codicils going on today because it's simply so easy to have this type of thing on computer and go in and make a change. In the old days, people used typewriters, and maybe you had a 90-page will, and it was going to cost you a lot to have that redone. One of the major reasons I see for writing a will is to take care of your minor children. Because what you can do in the will is nominate a guardian, and a guardian takes care of the child. The guardian makes health decisions, where the child lives, and all those types of things. Then you also want to nominate a conservator. Now, a conservator is the one that handles the money for the child until that child reaches age 18. So nominate, and the reason I say nominate, it's the district judge that actually makes the appointment, but you nominate in your will, and 99.9% of the time, that is exactly what happens, is your nomination is accepted. Now, I get a lot of questions. Do I have to leave at least $1 to each child? And the answer to that is no, absolutely not. Because what you want to do is be sure that you name your children. For example, if you have 3 children, Maddie, Eric, and Melina, what you want to do is then indicate a situation. For example, let's say that Maddie and Melina, you have already gifted them some money so that they could buy a house. They wanted to use it as a down payment. So it was, quotes, always understood they wouldn't take. But, if you don't mention them, then they can come forward and say, oh, I think Dad just forgot me. So if you have a circumstance like this where you've helped one child over the other, and in your mind you wanted to make sure that you're treating your children equally, well, that's when you would mention that child's name, but then not leave them out, but indicate they are not to take under the will. Here's one dad's will. He said, to my son, I leave the pleasure of earning a living. For 25 years, he thought the pleasure was mine. He was really mistaken. Now, Montana does have a rule that age 18, a child has a right to receive the inheritance without any regard to financial competency. So I know some of you listeners today may think back that you were really mature at age 18. And of course, there are those who really could handle money just because of their circumstances. They had to grow up fast, etc. But I've looked at some of the relatives that I have in this day and age, and I just don't feel that they should inherit a lot of money at age 18 simply because they are not mature enough financially to handle that. Now, what if you adopt children? You should know that they have the same rights as your biological children. I prefer the term biological children instead of natural children, but that's what I mean is, and for grandparents, you need to think about that as well, because your grandchildren that have been adopted, they have the same rights as your biological children do. Now, can you disinherit a spouse? And the answer to that question is a resounding no. Montana says that if a spouse has been disinherited, he or she has a right to an elective share. And the legislature has changed this elective share. It used to be a third, but now it's based on the number of years that the couple has been married. So here we have a chart that shows us an example. Let's go down the left-hand side, and you see 7. So if we're looking at somebody that's been married between 7 and 8 years, then the augmented estate is 21%. Now, augmented has a 3-page definition in the law. But basically, it's looking at all the property that the individual owned plus all the property that the spouse owned. But basically, we're looking at 21%. However, if you've been married 15 or more years, then you have a right as a surviving spouse to have 50% of the estate. And here's old Heine, as I call him. He made his wife the sole beneficiary on the condition that she remarry, because then there will be at least one man to regret my death. Now, yes, this is a real will. This is what people put in books, so I've had an opportunity to see what I think are some clever wills. But now let's look at kind of a situation that might arise in a family. We have here Bill and Veer. And Bill and Veer in the year 2018 are divorced. And Bill has a will. And in that will, he says, I leave $100,000 in my estate to Veer, my wife. Now remember, they are divorced. Oh, and I forgot to tell you, Bill has remarried. And Bill and Veer, had 3 children, but now Bill is married to Mary. So we've got a situation here. We've got Bill dying, where he has indicated he wants his former wife, and I have in red up there the term devotee. That's what they use in a will to refer to a beneficiary, a devotee. Well, how many of us know that? Beneficiary would tell us something. But anyway, we've got Veer as his devotee for that $100,000. So it's an interesting chart. We've got the new wife, we've got the former wife, we have Bill and Veer's children. And the question then becomes, who is really going to get that $100,000? Do you think it's going to be Veer because she was named in the will and she is the former wife? Do you think it's going to be Mary, the present wife, the 3 kids of Bill and Veer, or since we've got such a mess here, the state of Montana? I'm going to let you think about that for a second. Well, you ready for an answer? Here's the situation. We've got that $100,000 going to Bill and Veer's kids. And the reason is Montana passed a law, and I put the code number in there simply because when I would share this at some of my meetings, there were individuals there that would say, oh, this can't possibly be right. The kids get it because this code revokes any revocable disposition to a former spouse that was executed before the divorce. So in other words, basically, once we have a divorce, what that means is normally that you wouldn't want that person to receive the property. Now, wait a minute, if we do have a friendly divorce and they both still, have feelings for one another, they want to leave something to one another, the will then has to be dated after the divorce, not before the divorce. If it's before the divorce, this law rejects it, revokes it, so to speak, and it passes to the next level. So keep in mind, a divorce revokes a bequest of property to a former spouse. And that's something that the attorney in handling this, the divorce should take care of, to emphasize the need to write a new will, to name your present spouse, etc. So keep that in mind. And if you know somebody that's in that situation, you might want to share that with them to let them know that, gee, have you checked the wills that you had written before the divorce? Now, we've got some folks out there that have separation decrees. And you need to know that a separation decree is not considered as a divorce under the Montana Uniform Probate Code. Any bequest to a spouse is still effective. And even if you don't have a bequest in a will, the same thing's going to happen under Montana law because a separation decree is not a divorce. I had a lady at one of my meetings, and she indicated that she had been separated from her husband for 21 years, but she never got a divorce. But her attorney told her, oh, that's okay. This legal document means he won't receive it. And that is wrong in Montana. So if you know somebody's separated, not that you want to be a busybody, but you certainly might have them read our Mont Guide that we have on wills. So my reflection from my baneberries is you should write a will so that you can assure that your wishes are honored. And I don't want you to become the bane of someone's existence. Oh, I don't want to forget, and of course these are forget-me-nots, but I don't want to forget to tell you about how you can take care of your treasured personal property items. Because I started out by saying a will is going to control those items that have title to them. In other words, somebody's name is on there, it's in solely owned, it's a joint tenancy with right of survivorship, or it may be a tenants in common. But we all also have treasured personal property items. You know, for the guys, it might be guns and tools. For the ladies, it may be special dishes, linens, needlework, all those kinds of things. And of course, on my list now, I have wildflower photographs because we have blown some of those up and placed them in the house and really enjoy them and want to control who would receive those. And I think it's really important to think about these things. Here is an example of a bell. And you can see that I've titled it The Untold Story of the Bell. And the reason that I do this is a bell that we found in the house after my mom had passed away. And there's nobody left to tell the story of this bell. Where did it come from? Who owned it prior to now? Inside is kind of engraved 1881. But we have no concept how it wound up. How did Mom wind up with a school bell? Because, well, that's what I think it is, but she was not a school teacher. So if you have an item like this, tell the story. It's so easy in this day and age. You can, tape grandpa or grandma on your smartphone. You can have them write it down. There's just different ways to make sure those wonderful stories are shared. So here's what Montana says you need to do. What you want to do is first have a paragraph in your will. And the paragraph indicates, I have a separate listing of tangible personal property. In other words, what you're going to do is make sure that paragraph is in your will. And then the separate listing that you've got will describe the item very, making it distinct. Like in my case, my Grandma Ray's opal ring. I found out that that was her engagement ring and that they got married in 1919. So in 2019, that will make this ring 100 years old. And it's just a special ring. And then after I moved to Montana, I found some sapphires and had that made into a ring. So the whole idea is you describe the item very specifically, and then you put the relationship and the name of the individual that you want it. And I use an example here of my sister, Donna. Well, in our hometown, there happened to be another Donna Anderson at the time, which was her maiden name. And that person was, let's just say, the local kleptomaniac. And so you want to make sure it's your sister that gets it, not the local town kleptomaniac. Now let's take an example of somebody that has a coin collection. And we want to know, is it going to be John or Susan that's going to receive it? Because you see what Jack did, is he put John's name on the safe deposit box because he wanted somebody to be able to get in there upon his death. But in his separate listing, he has said he wants that coin collection to go to Susan. So think about that for a bit. Is it going to be John or Susan that receives the coin collection? Well, you've probably come up with your answer and why you think that it would be John because of the joint tenancy or Susan because of the separate listing. But the challenge with this is I found that these are two laws in Montana that conflict with one another. And the vast majority of my participants say, well, if the box was in joint tenancy, then John could claim it. Of course he could, and he'll probably win, but John knew that Jack wanted it to go to Susan, and Susan knew that as well. So I guess my question for you to think about is when I ask a bunch of attorneys about this as well, I got a 50-50 split. So are we going to have a court case here, or maybe this is something to think about? We need to ask ourselves if we have something in our safe deposit box that we really want to go to somebody else, do we want to have the box in joint tenancy with right of survivorship? Because by law, that joint tenant could say it's mine. And then the other one that says, well, separate listings should prevail, you got a court case and you got a mess and you've got a lot of expense. So maybe the wisest thing to do would be to keep the safe deposit box in one person's name only. And in that case, then the separate listing, there is no doubt, it would take control. The publication that we have available from Extension that explores this a little further is called Who Gets Grandma's Yellow Pie Plate? And it has to do with transferring non-titled property. So don't forget, make sure you have a separate listing of tangible personal property with your will or with your trust. And you see, it used to be you only did this with a will. Well, hey, now they've passed a law that says you can do the same thing with a trust, because a trust can only control what happens with titled property, and its title is in the name of the trust. And then you want to make sure that you coordinate the list that you have with what's in your safe deposit box. Now, this particular flower is called a sugar bowl. And I think it's a very beautiful one. And I'm relating it to a trust. You see, my mom used to have a sugar bowl in the top of the kitchen cabinet, and in that she was socking away money. And I'm sure I wasn't supposed to know that it was up there, but I did. And I got to say, I was really disappointed when she took the money out of the sugar bowl and bought a vacuum sweeper with it. As a kid, I really thought there were better ways to spend that money. So let's look at the sugar bowl as a trust. And basically, it's a legal entity that holds title to property. And this is going to be for the benefit of one or more persons or perhaps an entity. Because, you know, you could even have a trust where the income goes to some type of charity. And we have a lot of trusts out there. We have revocable, irrevocable, special needs, testamentary, A, B, or bypass trust, charitable, Q-tip, Q-dot, a lot of them. So what I'm going to do is just kind of emphasize some of the basics here. Now, when you decide to establish a trust, you need to say, what is the name of the trust? So here we have James Sims and Lois Sims as the trustees of the Sims Family Trust. And they have this dated on March 20th, 2018. And with a typical living trust, you have trustors and trustees. Now, the trustors are the money that put it in. The trustees, if you've got a living trust, could be the same as the trustors. That could be mom and dad. That could be grandpa and grandma, for example. You also want to think about who you want to be named as a successor trustee. This is the person or persons that would take over when you have a trustee fail to do what they should have done. So who can you name as a successor? How about one of your adult child? How about an adult grandchild or a trusted friend? Anybody could be a successor that you want. Another type of trustee could be a corporate trustee. In other words, we've decided we don't want to manage our assets anymore, and we've established a living trust, and maybe we want the local bank to be the trustee. Because you see, your trustees could up and die. And if they do, who is going to be the successor? And some people decide they would just like to start with the basics of having that trust at one of the locations. Now, beneficiaries are the ones, like your will in a way, it's to devisees, we say beneficiaries. They receive the income from the assets in the trust. And then, depending on what the trust document says, these beneficiaries can receive the assets upon the death of either the trustors or the trustees. The trust agreement is the written document containing instructions to the trustee. So this can be very outlined. I once heard of a trust that was over 90 pages because the grandfather was getting so stringent about what he wanted. He wanted the kids to go to a certain school, to go major in a certain major, etc. And what we're looking there is control for sure. But the trust agreement is you're just telling the trustee, this is the way I want you to use these proceeds. Now, a revocable living trust allows you to change the titles on any assets that you want put into the name of the trust. So in other words, you have to change title if you want the trust to control that particular asset that you've got. If you don't do that, that asset is not under control of the trust, and it will be distributed under Montana law of intestate succession when the trustor dies. Now, what kind of assets can you put in the name of a trust? How about your land? How about a checking account, certificates of deposit, securities such as stocks, bonds, and mutual funds? You can put these kinds of things into the name of the trust. And one of the things that your attorney may recommend is that you have a pour-over clause in the will in case there's any asset forgotten. And I know there's a lot of people that say, oh, there's no way people would forget an asset. But yeah, sometimes they do. So it's great to have individuals and have this pour-over clause in the will if you need it. The Mont Guide that we've got some information about revocable living trusts is titled here, and that is one that you can get from your county extension office or go to the web and Google Revocable Living Trust Montana, and this one will pop up. So my reflection from the Sugar Bowl is don't get bowled over with a trust until you learn more about it. Now here we have, in my mind, a beautiful Richard's geranium, and it's Richardson, sorry. So I want to introduce to you Grandma Richardson. She has an estate planning goal to treat her 5 grandchildren equally. So she has set aside some mutual funds and certificates of deposit. And we see here we've got Joe, Susan, Rob, Bob, and Tim. But if you look closely, we have way different balances. We have Joe with $10,523, and we have Tim that has $14,485. So in this case, with the TODs and the PODs, Grandma has not treated them equally. I mean, even though this was her goal. So what can Grandma do? She's got even distribution to her 5 grandkids, and she loves them all equally, so what is it she's going to do? Well, one alternative is to establish a testamentary trust in her will. And it's testamentary because it goes into effect after she passes away. What we can do then is designate the testamentary trust as the beneficiary of all the assets that a person owns. So in this case, all of these mutual funds and certificates of deposit will go into one big pot. Okay, think of all of these in one pot. And we can do that with other things too. Maybe we have life insurance with beneficiary designations. Well, we could make the trust the beneficiary of these assets. How about real estate? You see, I'm using a term there called beneficiary deed. And a beneficiary deed is something that can be filed before you die to help protect the value of that. As it was, we had a little situation with not having enough of that. Now, because you don't have to amend your multiple beneficiary designations, you're going to have more time. And if you change your mind about some of the areas, you could do so. And just, it's just that one beneficiary designation that you've got, having it to go into the testamentary trust. And it just allows you to even out those distributions. One of the advantages of that kind of trust is that the beneficiary's creditors have no right to reach the property that's in the trust. So you have left it in your trust for the benefit of your grandchild. Okay, the grandchild's creditors cannot grab into this property. Now, one of the things Grandma Richardson needs to think about is what distributions standards is she going to set up for her trust? Does she want it to be discretionary? Does she want it to be mandatory? Does she want to combine the two? Now, if you're leaving it up to the discretionary standard, you're going to talk with your trustees and say, I want you to use this trust money for the health, education, maintenance, and support of my grandchild. So it's trustee judgment all the way. Health, education, maintenance, and support. So now I'm going to make everybody that's listening today a trustee. And what we've got is Chris. And Chris would just love to take a trip during the summer to Europe. It would be very educational, says Chris. Aha, what do you think? How many of you would vote for having those funds provided to Chris to his trip to Europe? Well, it's very interesting. I find in my larger communities, they say, go ahead. And in my smaller communities say, no, there's some things that Christopher needs to learn before he goes on this kind of trip. Another standard that we've caught is called mandatory. And what this means is the property is distributed at a predetermined date or occurrence. So you could write in there for your one of your granddaughters that this would go to her at age 45. Or I had one lady at one of my meetings and she said, guess when I get my trust? I don't know, age 65. So she's going to have quite the retirement, but I think that's an example of parents that wanted their children to know how to work hard. You could also do it by age. You could say that these individuals, the beneficiaries, receive all funds upon reaching a certain age, or perhaps you want them to receive the funds at intervals like 25, 30, 35, etc. So it can be age. This is an interesting one. I ask my audiences about what age do you think is the best for a trust distribution. And typically it turns out age 31 to 40. Now, one of the things the attorney is going to tell you if you establish a trust is use percentages instead of dollar amount in case the values of the assets changed. And I think this is really important because in the old days we used to leave $10,000 to the church, 10,000 here, 10,000 there, and before you know it, our don't have much to live on. So do take advantage of using those percentages, because if you said 100,000 goes here and you don't even have 100,000, whatever that agency was would end up with it all. So think about that for your individual family situation. And here's some examples. We're going to give 50% to her grandson. Grandma Richardson is going to give the Montana 4-H Foundation 15%. And she loves MSU, so she's going to give the Alumni Foundation. And 20% then to the Montana Community Foundation. So if you look at a testamentary trust, it's one that could be a useful tool for a variety of situations. Now let's explore. This is what this is called, an explorer's junction, but I want to explore other uses for a testamentary trust. That's a trust. Okay, that's the ones we've been talking about. And now I'm going to look at a testamentary trust for minor children. Because if you have minor children, I told you that they would need to have somebody manage their assets till they're of age, and that's 18. And if we don't think they'll be mature enough, then we need to write a letter or something in the trust document that says what's going to happen there. Another reason for a testamentary trust is you may have what I'm terming nicely a financially incompetent heir. Maybe you've got one that can't manage money. Maybe you've got one with addiction problems. So if that be true, you may want to have the trust and have somebody be the trustee so that it'd be very clear under what circumstances this incompetent heir could access it, because it could be that they just shouldn't have any of it at all, because whatever they would get blown on drugs or something else. Another reason for a testamentary trust is to look at an incapacitated spouse. Maybe you've got one with Alzheimer's or some sort of dementia, and if you do, this is where a testamentary trust would really come in handy. I know last year I had somebody taking an example with, well, they weren't sure. Was it Alzheimer's? Was it dementia? But the point is, if you've got memory loss, we need to provide for that individual. And we had a situation like that in my family. I remember Uncle Lawrence Aunt Florence and Uncle Earl. And when Uncle Earl died, he did not have any accommodations made for Aunt Florence. And at that point, Aunt Florence was pretty forgetful, not thinking straight, and she got it in her mind she wanted to not kick the nephew off the ranch because she was sure that he was stealing. Well, you know, anyway, it would have been great if Uncle Earl had put those assets into a trust, and then there just wouldn't have been all that family drama. Now here I'm going to explore a situation that I've run into with, you see I've got years in red circles around, and these are the years in which these individuals passed away. I've got a son in '99, a daughter in 2005, and mom died in 2010. So the question becomes, who is going to receive the property? But the way I ask that is with a red lightning bolt on the sun. See, Dad has Alzheimer's. Mom is the last to die. So I want to know, well, how much would the son receive? And I'll give you a little quiz and let you think about that. Does the son receive nothing, 1/3, 1/7, or 1/9? Well, if you said nothing, you would be exactly right. You see, what happens is that mom passes away, now owning all the property, and upon her death, it goes to the dad with Alzheimer's. So now we've got a really sad situation because we need to appoint a guardian and conservator for dad. And that's a procedure a lot of people do not want to take their parents through. It can be embarrassing. It just is not something that many would want to try. So let's take advantage of the proceeding. Who's going to initiate that? Is it going to be the surviving son? How about one of the adult grandchildren? Or, last but not least, we do have public administrators in the counties that can do that. Now, the couple was Nancy and Larry. And we've got a problem. What are we going to do with Dad now? Where will he go? Can he possibly stay by himself? Could we use some sort of home health nursing? Would he even allow something like that? And then the bottom line is, could he afford it? So a testamentary trust can be used to protect assets, well and good, for minor children, those living with Alzheimer's, and it also protects a financially incompetent heir. So that's my reflection from the Explorer's Gentian. Well, my observation from the Lady Slipper is that it's about time to wrap it up. I hope I did steer you towards the advantages and disadvantages of a written will. Since we know 7 out of 10 pass away without writing one, you fall under state law to see where your property's going, and I think you would rather have control over that. We also took a look at some of the advantages and disadvantages of living and testamentary trusts. The living trusts are those you do now. You put the name of the property that you want in the trust in the name now. And then the testamentary trust is one that's formed with assets after you die. So in other words, that trust doesn't come into play until you're gone. And if you don't have a memory like this elephant's head, yes, that's right, can't you see the ears and the nose? It's fun. We have 43 different mock guides available with MSU extension. Just go to this website, Estate Planning, and you can read something about each one of those mock guides. And don't forget, the mock guides are also available from your local MSU County Extension agent. Or feel free to email me here in the office at getting, GOETTING, @montana.edu. So again, Marcia Getting on this end. I am the MSU Family Economics Specialist. And if you find that you have any questions that I wasn't quite clear on one thing or another, I would invite you to send me an email. My email address is down there at the bottom. I do educational programs across the state, so if here I'm in town and you would like to learn more, I would certainly invite you to one of those meetings. Thank you very much, and good luck with your FSA Financial and Production Management course.